Right, and now welcome everyone to today's revision of L4M3. In this event, we are about to look at the key topics of this module and help you prepare for upcoming May exam. Due to lack of time, we only plan for 1 hour and 30 minutes. So we only focus on the key topics that have pretty many questions or the majority of questions in the exam. Therefore, if you have any further question, you can put in the chat. Today, with our Form 3 revision, we only focus on some key topics. First, like the formation contract and some key schedule. Second, the specification, KPI, and SOA. And third, about express implied terms, about some key terms in the contract and the payment arrangement. Now, let's go into the first part about the formation contract. At the end of this event, you can see that I show you a few questions, a few couple debating questions about L4M3. And I already, in this event, I will present some of the key topics. And then with the questions, I may demonstrate how SIP may ask you in the exam. Now let's go to the first part about the formation of contract. As you know, the study guide starts with some documents related to the contract. We have some key concepts like invitation tender, request for quotation, and again, we look at some of the process for selecting the supplier. We have open tendering, restricted tendering, and request for quotation. As you know, request for quotation is very short and informal process of selecting the supplier. We only consider the price and ask the supplier to submit a price based on the known specification. RQ is often used when it should be used actually when we know the suppliers already, like the suppliers are already shortlisted or they are within a framework agreement and we can send them RFQ and then we can award them the contract if their price fits into our budget or if they provide a very competitive price. Otherwise, tendering would be better if the project is more expensive or we need to qualify or look at the risk from the supplier. And with tendering, we may use different criteria to assess and ensure that the supplier is fit to deliver the contract. On other hand, a contract, especially for very complex projects, a contract could be very complicated and the contract body alone cannot convey or cover the full risk of the contract. Therefore, we may need to have some other documents like the different schedules to complement the contract. Here, with the contract body, maybe it could be quite difficult for us to include every details like about measurement framework or about performance measurement or about specification and other matters. So we may need to include the schedules or in some language, in other countries, they can be called the annex. Therefore, here we may include some schedules like about health safety or about code conduct. And there are some other schedules on the standards, on the specification, on performance measurement, and so on. And of course, we have the non-disclosure agreement. They can form part of the contract and they can be referred to, by within the contract body. Another part, I think this is more important. This is about the different elements to the contract formation. As you know, the study guide suggests, actually now they say 6 elements to contract formation. We have offer, acceptance, the consideration, capacity, intention to be legally binding, and enforceable. Okay, so I'm not sure about the final part here. Actually, I already made a graph about the relationship between these elements. So within the contract formation, here I am showing the relationship between these 5 elements. Okay, so we have the offer and the acceptance. When an offer meets an acceptance, we have an agreement. And this agreement could be enforceable or unenforceable in the app law. Enforceability here is very important. Enforceability means the contract, if it is enforceable, it means that when you have some dispute with your supplier, then you can sue them to the competent court, and the court may issue an order to make the other party conform. So a contract is part of the law, and it creates the obligations. An enforceable contract can only do that. So when we have enforceable contract, then the other party has the obligations and they must do that. Otherwise, they may face the consequences. Therefore, creating an enforceable contract is very important, and we need to ensure that our agreement, our document has all of these 5 elements. When the offer and acceptance meet each other, then we have an agreement. And if you argue this agreement to the court, for example, then the court will consider about 2 or 3 other elements. They may consider about the capacity of the one who creates the offer acceptance. They may consider about the consideration, whether this agreement has sufficient consideration, and they consider about the intention to be legally binding. So if it has all of these elements, then this agreement is an enforceable contract. And if the supplier doesn't perform that, they don't comply with that, then they may face the consequences, like they need to pay the damages or they need to perform something specific. In other words, specific performance. But the case law, especially when we learn from SIP, it instructs us about the English law. So we need to know about the case law here. The case law has English case law has many cases about offer, acceptance, consideration, intention, and capacity. So we need to understand the rules here. For the purpose of L4M3 exam, they rarely, actually, as I know, they have never asked about consideration and intention. So I will have you to analyze the offer and acceptance. To talk about offer and acceptance, we also need to distinguish between offer and the invitation to treat. There are no definitions about these things. No definition on offer, no definition on invitation to treat. Instead, we need to memorize the cases of offer and invitation to treat. And by the case law, they can identify that there are some actions or there are some statements that can be a firm offer, and other actions or other statement could only be the invitation to treat. With the offer, then we have the quotation from the supplier, obviously, or the bid to tender, or the bid to auction, and the goods display on automated machine, vending machine. They all of them are offer. With invitation to treat, we have a few cases like display of goods on shelf or window, or the advertisement, and the invitation to tender. They are invitation to treat. An offer is open to be accepted, and once accepted, it creates an agreement, and then that agreement could be enforceable or not depending on other elements. Otherwise, with an invitation to treat, it is not open to acceptance, and we cannot accept this, and it doesn't create any contract. So, for example, when we see some goods on window or store shelf, it doesn't mean that you can just take that and pay and then you get that. But actually, you need to get that good to the cashier counter, and the cashier of the store of that store or the shop assistant should agree to sell that to you. At the time you bring that to the counter, they still have the right to reject your offer. So offer and invitation to treat will create different type of relationship, and therefore we need to distinguish these. In the exam, you may see a few questions about this one, like with a scenario like some woman goes to a shop and she saw a dress on the shop window, like with different price tag, and then she wants to buy that, and then the shop assistant confirm about the price, and she agreed that they should honor the price tag. So the question is whether that request is enforceable, or whether the shop assistant should comply with her request or not. Okay, so this is the first part on offer and invitation to treat. Let's move on with other part. Um, Offer could be terminated by some other elements, like the offer could have some time period, and when that time period has lapsed, the offer is terminated, and that offer is no longer be able to be accepted. Otherwise, once the offer is accepted, then it also terminates that offer, and it can no longer accept it. It can no longer be accepted again. Or when the offer is dead, or when the offer, if it is a company, if it goes into insolvency, then the offer is automatically terminated. When the offer is rejected, it is on the rejection also terminates the offer. And if the offeree makes a counter offer, then the offer is also terminated. The withdrawal of the offer also terminates that. So you need to memorize all these things, and we could have a simple question in the exam about the termination offer. And I don't want you to miss any score or any points of this question. On other hand, we have the acceptance. With the acceptance, we also have some legal rules, but they are not as complex as offer and invitation to treat. The acceptance here must be unequivocal, and it should mirror the offer. So there are very few rules and principles here. Unequivocal means the offer must be clear and definite, and it must be communicated to the offerer. When the offerer receives that kind of communication, then the contract is formed. However, we have an exception here based on the mailbox rule. Under that rule, then when the mail containing the communication of acceptance is posted and postage paid, then it is deemed that the acceptance is already communicated and the contract is formed at that time. Therefore, we must be very careful when we deal with the offer acceptance in the long chain of communication, especially when you communicate that by mail. Nowadays, we tend to communicate through electronic device. Everyone now has an email address, and everyone now has something like WhatsApp or other messaging apps. So that kind of communication is more instant and removes the risk of macro and ambiguous other rules regarding the communication. However, then we still need to be very careful about communication here. For example, the supplier may reply your request or your offer to your other mailbox, and that could create some legal relationship, and you need to be very careful about communication here. Like in your offer, you may need to include some lines about the acceptance is only considered to be received if it is communicated to this or that email address. So we need to be very clear on acceptance here, and if it is possible, you can also include some lines in your offer about the conditions of acceptance. And when we exchange the standard terms, condition, and forms with the other party, like you can issue a request for quotation, and then you receive a quotation, and then you can issue a purchase order. Then that kind of communication can create a situation known as battle of the forms. This term refers to a situation where we are not sure about what kind of terms and conditions apply to certain contract or relationship, because all of the documents in the exchange, like purchase order or quotation, all of them contain the terms and conditions of respective party. So we don't have very clear concept. We don't know exactly what kind of terms may apply, whether it is supplier or the buyer. So this could create some form of dispute. And in English contract law, they already solve this kind of issue. A contract is formed when we have offer and we have a valid acceptance. So they still apply the principles of offer and acceptance. When you issue a purchase order, when you issue a request for quotation, then your communication is an invitation to treat. Then the supplier may reply with a quotation that is an offer, and then you issue a purchase order with different term and condition. So with your new terms and condition, your purchase order is actually a counter offer, and then the supplier may reply with an order acknowledgement. The order acknowledgement could be an acceptance if it contains no further conditions, but it could create a form of counteroffer again if it contains the supplier's own terms and conditions. And then they can deliver the goods to your premise and show the delivery note. And by that action, they can create another offer. They can create another offer. So with the new offer, the previous offer is terminated. And if your company has someone stand there and sign the delivery note, it can be considered as the acceptance. So in this case, we can see that the last short or the last form that creates the last counteroffer could be the one who which rules the relationship here. So with battle of the forms, we need to be very careful about the communication. If we use the supplier terms and conditions, we may not be protected by some rules or some contract clauses that we prepare by our own, and that create certain situations like you are not protected from the losses or damages by faulty product. So in that case, we must be very careful and ensure that the contract is fairly negotiated, or it represent or it should protect your own interest. So when first of all, when the supplier send an order acknowledgement, you need to review that whether it has the term condition. If it has no further term condition, then it's okay. It is accepted. But if the order acknowledgement has the supplier's own term as condition, you need to give them another communication, another letter about your term condition and the specified product as well as the deadline, like purchase order confirmation. By that way, you can create a counter offer and make them like must accept that counter offer. Another part of this one is about misrepresentation. Um, when we have a contract, then it should reflect the balance of power, and the every party must have the freedom to contract. They have the right to protect themselves from a bad bargain. But in certain situations, when a party try to dilute or try to trick the other party into the contract, then that contract doesn't reflect the balance of power, doesn't reflect the information symmetry. It doesn't reflect the free will of every party. So this kind of contract is defected, and it should be remedied in certain cases. So in this case, we have misrepresentation. This is a case where we already have the contract. It has all the 5 elements of acceptance, consideration, intention, and capacity, all of them. But the process leading to the contract is faulty, and it includes the misleading information. We have 3 types of misrepresentation. We have the fraudulent misrepresentation, where the party at fault intentionally make some very misinformation and try to trick the other party into the contract. Or we have the negligent misrepresentation. This is a lack of duty of care. In this case, the party at fault, although they are not intentionally doing this, but they don't check the information and they provide the wrong information that trick the other party into the contract. And finally, we have the innocent misrepresentation. This is quite rare. In fact, the party at fault doesn't know that they provide the wrong information, although they should check that, but actually they don't know. And at the time of confirmation, they have no other way to check the information. So with misrepresentation, we have a few legal standards here. First, there must be a statement of fact and not a statement of law. A statement of fact is a piece of information that a party gives to another. And that kind of information should express about some data or about some information that um, may influence the other party's decision. And that statement of fact is false. And the statement of fact in this question induce the other party, induce the injured party into the contract. So with misrepresentation, we must have some kind of remedy. So remedies are the measures that the court or the parties could apply to place or restore the balance here. With with misrepresentation, this is a very serious fault of contract formation. So the court may consider about rescission of contract. Rescission contract is about cancel the contract or void the contract. This is an equitable measure applicable by a competent court. And they try to place the injured party to the position as close as possible, as the contract had never been agreed. So, in other words, the contract is deemed as had never happened. And they try to restore the position of both parties. Everything treated in the contract is given back to every parties. And with fraudulent and negligent misrepresentation, the party at fault must also pay the damages. Now, let's continue with the part on different type of agreement. So within procurement and supply job, we have many types of agreement. We could have the one of contract where we only purchase the product or service once and not in incurring matter. We could have the term contract, like you can sign a supply contract with your supplier. They need to provide you with the materials for an ongoing period, like 1, 2 years or something like that. We could have the contract for hire and lease, where you only use the assets for a short period of time. And we have a special type of agreement that is framework agreement. So framework agreement is a very special case here with the other three types of agreements like one of contract, term contract, or hire and lease. They are all contract. They are all enforceable contract. And as a buyer, you need to pay for those products or services. But with framework agreement, it is not yet a contract. Actually, it just provides a frame or a skeleton for the formation and operation of later contract. So framework agreement is pretty versatile tool for the buyer, especially when we have frequent, but not we cannot predict the occurrence of the needs here, and especially when you need to provide the service or you need to contract with a wide range of suppliers, and you're not sure about when you need them. In other cases, for example, you have often pretty sudden requirement from the user, the end users. So you can try to find a few suppliers and include them within a list of framework agreement. And then when the user raises a requisition, then you can contact that supplier and require them to perform the job. Okay, you can just send a purchase order. So framework agreement is pretty versatile, and you can use that in many cases, and it can bring pretty many benefits to the buying party. Especially, you can use framework agreement to shorten the purchasing process, and it is particularly helpful in public procurement, where the public agency must often go through the tendering process. This could be quite long, especially normally the regulation often require minimum time frame for each step within the tendering process. But framework agreement shorten that and give the agency a shortcut to award the contract to the supplier. Framework agreement could be signed between a buyer and a supplier, or between a buyer and multiple suppliers. Uh, Under the framework agreement, as you know, it is not a contract. But when we issue a purchase order under this framework agreement, and the supplier accept that, it creates a contract with the term and condition of the framework agreement. So we need to have something known as the core of mechanism. Um, Co-op mechanism means how you may select the supplier from the list of framework agreement here. You can either place a direct co-op, just look at the list of supplier and see which supplier is suitable for this kind of contract or for this kind of opportunity or work, and then you can just send the purchase order directly to that supplier. Or you can organize a mini competition where we organize a small bidding process for the suppliers within that framework agreement. As you can see, framework agreement could be a pretty powerful tool for the buyer, and you can consider about using this in your next contract. Otherwise, with the exam, we also have about four, three, four, or five questions about framework agreement, and most particularly about how we can use its core of mechanism. Now, let's move on with the second topic on the specification, KPI, and SOA. With the specification, actually, I think L4M3 reiterate pretty much from L4M2. And again, we look at two different types of specification, that is conformance and performance. Now, we also look at the content, the advantages and disadvantages of these specifications. I think that it is pretty clear now for every SIP student, especially when you already studied L4M2. So we have conformance specification, which uh, which also known as the input specification or technical specification. These specifications are often details the uh, technical aspect like the dimensions, like the materials, like the color or the brand name of the products. And the and that kind of specification tend to be quite exact, and um, we can just send specification and the supplier must reply us with the quotation of that requirement. The component specification may include some technical details or some standard, but however, the component specification could be quite rigid, and especially when you refer to the standard, it may not be up to date. It may encourage the compliance. and the supplier has no room to innovate. And it also requires the buyer to have technical knowledge about the topic, or if they don't, then we may risk to issue an incomplete specification, and that may shift the risk to the buyer. So the buyer here will be responsible for the product failure. Otherwise, the performance specification could be about outcome or output. They are easier to prepare, and we can uh, only need to list a list of outcome or output, and the supplier has the freedom to generate their own idea or um, solutions to our specification. And therefore, it shifts the liability for product failure to the supplier. So performance specification sounds great in the book, but it has very big problem. Something like when you have only performance specification, then actually when supplier suggests some solution, we're not sure like whether that solution fits our requirement or not. So performance specification increase the level of assessment. We are not sure about whether we can confirm or whether the solution that supplier suggests fits that kind of specification, and we may incur further costs for the assessment. To write a specification, we should not write blank from a blank page. But we may consult the some information to develop the specification. The first piece of information is the input from the user. They must address a few information like their requirements, could be outcome or output. And then from that, we can develop further by seeking the technical advice from relevant department, engineering, technical department, and so on. Or we can consult with the existing catalog or standard, and we may engage in the market dialogue with the suppliers. With market dialogue, it means that we are not sure about what we need, so we may issue the request for proposal, and the supplier may reply with some proposal, with some technical proposal, and their financial suggestion. So we look at those proposals, and we consider whether which kind of specification, which kind of proposal may fit our expectation. Here, also the study guide and the exam may focus again on the use of standard within specification. The standard may create some kind of shortcut to the specification, since we can use some reference to international or national standard. And it level the field. So we can reach to international suppliers, especially when we use the ISO standard. Here, you also need to understand a few key ISO standards like ISO 9001 or ISO 14001. ISO 9001 is a standard for quality management system, while the other ISO standard is for environment management system. Now, let's move on with KPIs and SOA. First, with KPI, they are the measures or they are the kind of like a ruler or something that measures the performance of the supplier. We can set out different type of KPI under contract. And there are a few common KPIs like on-time delivery or defect rate or response time or satisfaction score. The KPI could be qualitative or quantitative. Qualitative KPI means we assess KPI based on opinion, based on subjective assessment. Otherwise, quantitative KPI could be measured in hard number in numerical way, like with on-time info delivery, we can measure in the rate of on-time and info delivery. KPI has a purpose to measure the performance of the supplier and set out and clarify the expectation from the buyer. In the contract, KPI could be a part of the contract. It could be like a schedule to the contract, and within that schedule, you need to list all the potential KPI and their definition and how you measure them as well as the data regarding the performance. Normally, with a professional buyer, they may manage the suppliers through a system, and KPI is core of any performance measurement. We need to have the data on performance before we discuss with them about how to improve that. With the exam, the KPI question tend to be quite practical. They tend to ask you about the purposes of KPI or certain common KPI in certain scenario. It could be the question on KPI for a call center. We can have a few KPIs like the pickup time or the satisfaction score of the user or of the customer to that service provider, or the number of complaints we receive through the call center. With supply of goods, we may include a few KPIs like percentage of on-time info delivery or the defective rate or the number of handout delivery note. We can also have other KPIs like the number of invoice processed or the uptime or any other KPI that you can think of for different scenario. On other hand, we have the SOA. SOA is abbreviation for service level agreement. This is it could be a part of a contractual agreement, or it could be a standalone contract. It defines the service expectations between the supplier and the buyer, and it often set out the target and also the remedies for the performance of supplier. With SOA, in other words, the supplier or the service provider promises to maintain certain level, and if they fall under that level, they may face the consequences. An SOA may include some elements. First, it needs to define the scope of service using the Starburst method or 7W1H method. Here, they often define what kind of service to be performed and the other questions like when it should be performed by whom, um, to whom it benefits, and the limit of service like the time period or the geographical limit. The SLA must contain the section of the target and what is the target for the supplier to perform. And if they fail to do that, then what could be the remedy? The SLA can also include the measurement like KPI. KPI SOA complement each other. The KPI gives us the assessment and gives us the data, while SOA give us the target and the remedy. So we need to use them in combination. However, within a complex contract, KPI and SOA could be separate schedules to the contract. So here we need to distinguish between KPI SOA, and if we already have the KPI in other part, the SOA here to avoid conflict with that KPI, with those KPI. The SOA should refer to that KPI and not to reiterate the KPI here. And SOA, if you want it to be more flexible, we can include the part on adjustment or variation of SOA as a part of this agreement. The second part on KPI SOA is not too lengthy, and actually in study guide you can see they don't provide much information there. The question here tend to be very practical, and you need to have certain level of experience with these kind of tools and apply that in the exam. So with the exam, actually the knowledge of KPI, SOA, and specification is not much, but it is more about how you apply these things into the question. So the first thing here is that you need to read the question carefully and apply what you know about these concepts. Now, let's move on with the final part of the revision about different contract terms. There are many ways to categorize the contract terms. The first way is between express and implied terms. They are the two kind of terms that you can see in the contract. Express terms, the one that define the party rights and obligation, and they are written down into the contract. Otherwise, implied terms are not present in the contract, but they are implied by law or custom. So both of them are applicable, and therefore we need to be very aware of potential express and implied terms. Here, the express terms are the one explicitly written down in the contract, and they must be clear and unambiguous to be enforceable. But sometimes the express term could be unenforceable or ineffective due to its conflict with certain statute or law and regulations. Otherwise, implied terms are not stated under the contract, but it still define part of the contract. And for example, when we purchase a good from the supermarket, it must still satisfy certain regulatory requirements, like to have the satisfactory quality. And even though we don't have any contract for such purchase, but this could be an very an implied term about satisfactory quality. The implied term could be applicable from different sources. It could be complement the express term because the contract doesn't specify certain thing or doesn't specify certain obligation or certain relationship or certain conflict. Therefore, we need to use implied term to complement that. For example, the contract with your supplier may not cover the damages or the liability of the supplier, But we have implied term on that, and that comes from the common law, the case law. Implied term may come from the statute, like some legislation, like the Sales of Goods Act 1979. Or it could be applicable from custom. And I think that internationally, we recognize some certain custom like UCP 600 is the custom for, that is a custom for documentary credit, or in other words, we have the custom for letter of credit. Here, you also need to understand a few key UK legislations on contract, because we are studying the implied term, and there could be some question about implied term as well. So there are three legislations that you need to read. First, we have the Sales of Goods Act 1979, the Unfair Contract Terms Act, and Misrepresentation Act. Under the Sale Goods Act, it established the basic obligations for the buyer and the seller under a contract for sale. So under this act, they distinguish between condition, warranty, and innominate. This thing will be elaborated further in L4M3. And they also set out some certain obligations for the seller and the buyer. Okay, so seller here must be professional traders. There are a few implied obligations, like the seller must have the right to sell. The goods must be fit for purpose. We could have different type fit for purpose, like sale by discretion, sale by example, or satisfactory quality. There are three types of fit for purpose here. And finally, the seller must let the buyer to enjoy the quiet possession of goods. And the buyer has the implied obligation to pay and to accept the goods ready to deliver to the buyer. Under Unfair Contract Terms Act, they eliminate certain, or they make certain terms to be ineffective, even they are expressed, like the inclusion of limitation of liability arising from negligence, or that causes death or injuries, or the express term that try to exclude or limit the liability arising from violation of certain key obligations, like the three key obligations under the Sales of Goods Act. So as you could be aware that there are questions about this one, like certain type of obligation or certain type of liability or certain type of exclusion is prohibited by the statute or by the law. And therefore, we must be very careful when we make our own standard term and condition. Here, there are a few other principles in Latin phrases. Like cavit emptor. Cavit emptor means let the buyer beware. It means that the buyer is responsible for examining the goods, and they must be careful before making the decision to purchase. Otherwise, we have the phrase quantum merit. This is a phrase means as much as he earns. This is a mechanism for compensation, and it creates certain kind of quasi-contract and the underlying mechanism for unfair enrichment. So when under the contract, when we terminate the contract prematurely, like when the supplier violate a um, very serious clause. So we have the right to terminate contract, but the supplier and the buyer must also pay for the unfair enrichment. Now, let's move on with the standard term condition. So as you know, implied terms remove it prohibits certain type of obligation. And when we draft our term and condition, we must be very aware of that. Especially with standard term condition, the term condition here are often found in purchase order or quotation, and but they must be reviewed for legal application. So with standard term condition, we can use that as a part of negotiation, or we can use that as a part of purchase process. But we must be very careful about this and be aware of certain limits under the um, legislation. So as the buyer, you need to review the term condition and maybe require some legal professional, some lawyer to do that for you. Otherwise, you can use a modern form contract. Otherwise, you can use a modern form contract to as the start of a contract negotiation. These modern form contracts are prepared by professional bodies worldwide, like SIP or FIDIC or ITC or IMEC. That is the Institute for Mechanical Engineering. Or we have the modern form contract from International Trade Center, or we have the modern form contract from International Chambers of Commerce. They are provided by professional body, and they tend to be very professional. They have very detailed and correct terminologies for the contract and standardize the transactions worldwide. So these kind of modern contract tend to be very, very equal and ensure the balance between the buyer and the supplier or the seller. Therefore, they tend to be acceptable worldwide, and you can use that to negotiate with your supplier. And they also review this very carefully and ensure that there's no conflict with the implied term. So we can use the model for contract with the confidence that they are drafted very carefully. And we can use that directly from certain professional bodies. The modern form contract may provide the correct professional writing and very professional terminology, and they are acceptable worldwide. But they are still general, and they still need to be specified to fit your cases or to fit your project. Therefore, when we try to edit this kind of form, we still need to have the advice from a professional lawyer or a professional, a legal professional. They may give us the advice on how we should write this kind of contract. Now, let's look at different types of contractual. Now, let's look at different types of contract terms like liability or indemnity. But before that, you need to understand the implication of contractual obligations. When we have the contract, then it creates the obligation. Obligation could be primary or secondary. Primary obligations are the one that the party are required to perform. Like when we sign contract for sale, the buyer is obliged to accept the goods when they are delivered, and they are also obliged to pay. Otherwise, the suppliers is obliged to deliver the goods. All of them are primary obligations. Otherwise, if the parties violate those primary obligations, they incur secondary obligation. Secondary obligation only arises when there is a breach of contract. Normally, we have the secondary obligation in the form of damages or in the form of specific performance. But specific performance can only be awarded by a competent court. So these kind of obligations are very important. It helps us to distinguish between different types of terms. Here we have a few terms like indemnity, exclusion, and liquidated damages. Indemnity is a promise from a party to another, and normally a promise to compensate or promise to hold the other party harmless from some trigger event or the consequences of some trigger event. Normally, it protects the damages or the claim from a third party. An indemnity is a transfer risk, and it is a primary obligation, although it is conditional. The obligation here only arises when there is uh, when the trigger event happens. In practice, the indemnity clause is often used when there is a risk regarding the third party. Like you can ask the supplier to provide an indemnity when they do some work in the public and they may cause the harm to the public, like the passerby or the neighbor. Second, we have the exclusion of liability. So the word here, liability, means they are the secondary obligation. This kind of clause excludes the breaching party from performing the secondary obligation or from performing the liability. In other words, for certain cases, for certain circumstances, they are not required to pay the damages. The most common form of exclusion of liability is the force majeure clause. Force majeure clause. This kind of clause is used when we see there are certain risks of disruptive event like the act of God, natural disasters, or certain man-made disaster like war or um, strike or pandemic. So this kind of clause exclude the breaching party from performing or paying the damages. And when the clause or when that event is over, um, the um, the breaching party must still perform the contract. And exclusion liability is an express term. So you need to drop this quite carefully and look at review the implication of this kind of exclusion. Next, we have the liquidated damages. It is an attempt to predefine the secondary obligation and maybe put a cap on the secondary obligation. To be enforceable, it should be a genuine estimate of loss. And it is an attempt by both parties to imagine what kind of loss could happen and what kind of loss could happen and what could be the potential loss from such breach. It is often used when we have the breach or when we have the obligation that we find very difficult to measure the actual damages. Insurance is another part and another clause that we may include in the contract. And we may require the supplier to provide the evidence of certain insurance, like they need to provide employer insurance or product insurance or professional indemnity insurance. Um, this kind of these kind of insurances are applicable for the business and they protect the insured from certain risks. For example, professional indemnity insurance protect the professional provider like lawyer, accountant, or consultant from the liability arising from bad advice or bad practice. And when the service providers commit some kind of fault and they cause the damages to their plan, the insurer will pay them, will pay the liability instead. We also have a very important part on the difference between penalty and liquidated damages. And actually, you need to read certain case law about this. The first case law is Dunlop Pneumatic Type Co. Limited versus New Garage and Motor Co. Limited in 1915. This case law established the principles to distinguish between liquidated damages and penalty. So liquidated damages must be a genuine estimate of loss and must be expressed in the contract. It must clearly express the amount of loss and potential impact on the party. And if the clause is such genuine estimate, then it is enforceable. For penalty, it is the exorbitant payment and has no relation. It is well beyond the possible or real damages, and therefore it is unenforceable because it is unfair to the parties. However, this principle is reversed in a new case law in 2015 between Cavendish Square Holding BV and Talal Al Madesi. So with both penalty and liquidated damages, they are all secondary obligation. While liquidated damages are still genuine estimate of loss and still enforceable, then penalty is more about deterrence and about some genuine interest of the business that should be protected. So with that purpose, both penalty and liquidated damages must be enforceable. This is a new principle. However, then I believe that SIP still apply the old principle from Dunlop v. New Garage from 1915. Finally, let's look at different payment terms. There are different arrangements for payment, like we could specify the total sum of the contract under the lump sum contract, or we can prepare a pricing schedule or the schedule of rates. Under this schedule, the party agreed to certain unit price of item, and the supplier may charge the buyer based on that kind of unit price. For long contract, we have the index-based pricing. This allows the contract price to be variable and fluctuate according to the market condition. And finally, we can pay the supplier based on their actual cost and the margin on the markup. Or we can create a dynamic system of incentive payment. With lump sum, it is simply a contract for total price. And we often use that with a contract that we already know about the scope and the quantity that we are about to use. With a scheduled rate, we often use that when we know about the input and the unit price is quite stated. But we're not sure about quantity to be provided. So we may use the only a list of unit price. And with variable pricing, we allow the price to be fluctuate. This is particularly helpful when the contract is longer and the input is commodity or something that fluctuates wildly according to the market. With cost plus, it is often used in construction, where we pay the supplier the total cost they undertake the project plus some equal to their markup. So we have a few arrangements here, like cost plus fixed fee. Like I agree to pay my supplier $1 million and plus $100,000 for their markup. Or we can have the cost plus fixed percentage. Like I agree to pay the actual cost and 10% on top of that cost as part of their markup. Or we can use the pain share gain share. With pain share gain share, we set up a target cost, and if they do beyond that, we share the excess cost. Or if they can perform under that level, then we can share the incentive. With simple cost plus, like cost plus fixed fee or cost plus fixed percentage, then we don't have the total control because the supplier knows that they will be paid according to the actual cost and a markup. So they can inflate the price and they don't want to share the transparency about their price and their cost. They can collude with the subcontractor to inflate the price and overcharge the buyer. So pain share gain share agreement could fix this problem. This is the collaborative contract where cost, risk, and saving are shared. And we can share the difference if the contract is performed beyond the cost level or under the cost level. If the supplier provide or charge beyond the cost level, then all the pain will be distributed between the buyer and the supplier. And if the supplier can do under the target cost, then the gain here will be shared between both parties. So this kind of agreement provides some level of incentive and motivate the supplier to perform better. With pain share gain share, it is more flexible and could be applicable in more innovative projects. It shared the risk between parties, and everyone will be capitalized. They know that the risk will be shared, and they can also make more venture. They can make more. They can make bolder decision regarding the project and may achieve a breakthrough in that method. So we just scan through a few key parts in the study guide. Now, let's look at certain questions, and let me show you a few questions here. Since we have very little time, so I will explain this question directly. First, we have a question about misrepresentation, and the question simply about the remedies for this kind of action, or this kind of agreement. Sorry, this kind of behavior, misrepresentation. So there are four options here. The contract is void, rescission of contract, injunction, and damages. The right combination here is 2 and 4, rescission and damages. This is very well defined in the study guide. Void contract here means there's no contract at all. But rescission is an equitable remedy, and they must be awarded by the court. Okay, so rescission is actual remedy for misrepresentation. The second question about how to create specification. We have also four options, and we select three from this. We have we can select from an incumbent supplier or maintenance service or alternative supplier and measurement information. So I believe that the measurement information here is about the database and data or the catalog that you have in your server or in your computer. So it could be used to create a new specification. Otherwise, we can engage with the suppliers to help us devise a new specification. So the answer includes incumbent supplier, alternative supplier, and measurement information, 1, 3, and 4. Okay, this question could be a little bit more difficult. Now we have Sprint Carriers Private Limited is a national provider of parcel services. So they are providing the delivery service, right? And a high proportion of the service it provide undertaken through a subcontracted network of delivery drivers. So it contract with some individual driver and they perform tasks for them. It is presently renegotiating all of its subcontracted services and is looking to develop service level agreements, SLA, with its providers. Which of the following should form part of the SLA document? So you can see that we have the question about SLA and actually about what kind of information should be included within an SLA. And we need to look at this question in the full picture. This is about our service and they are about delivery service, right? So there are four options here. Geographic area covered by subcontractor, percentage of company policies adhered to, total number of completed deliveries each month, or actual percentage against target of 99%. If we look at this, then it could be very confused. Let's look at each option separately. Geographical area. Okay, so this could be a part of SOA because this is the definition of service. Service here is delivery. And with SOA, we must have the definition of service. So geographic area could be part of that because it answers the question where. Without the definition, the driver could, they don't know actually. The drivers may not know where or which area they need to cover and deliver to. So I think it is the correct answer. Would be a percentage of company policy adhered to. This could be a KPI. It doesn't give us any target. This could be a KPI. And also with delivery service, I don't know, I don't think it is relevant to this scenario. With option C, the total number of completed deliveries each month. Also, this could be a KPI as well. And with D, the actual percentage against target of 99%. With D, we have the word actual. So it's not about the agreement. It's about actual performance. It's a data. So consider all of these, I think that the option A should be the correct answer. Okay, so let's look at this. Exclusion of liability is restricted by statute for which of the following? Select to that apply. With this one, you can see that the question is about the implied term. It's about the statute. And I'm talking about Unfair Contract Terms Act, right, as I analyzed earlier. So if we scroll back at the Unfair Contract Term Act slide here, you can see that we have two types of exclusion that is prohibited. First, which arising from negligence, right? And second, arising from violation of implied term or breach of implied term. So the answer here should be A and C. Okay, negligence and breach of implied term. As you can see, I already explained this with the part on statute on Unfair Contract Terms Act. Now, let's look at this. Dunlop Limited supplied tie to Garrett Limited agreed in the contract. It would pay Dunlop $50 per tie sold in bridge. It subsequently sold tie at below the listed price, which was one of the bridge mentioned in the contract. What is the $50 per tie an example of? So actually, they don't even change the name of this case, and it is a very famous case law from 1915. I already explained this in penalty and liquidated damages part. So it is actually the case, and you can easily select that this is a case of liquidated damages, and this kind of clause is enforceable. Now, let's look at this. You are a buyer who is presently collecting the necessary data and information for a forthcoming tender. The project is for the supply and installation of numerous car park barriers and related equipment. It will also need to include the provision of spare parts to support the maintenance provision for an ongoing period. Which of the following would be an appropriate pricing arrangement? Here, we have a project for installation and maintenance of car park equipment and include the spare parts for maintenance. So the scope contract here is not very well known, although we know that there is a project about car park barrier, but the part on spare part should be applied. We don't know how much or how many parts we will use in the long run. So I think that it is not possible to use the fixed price here. Cost plus and cost reimbursement are the same. So we may use pricing schedule or the schedule rate, and we may list the unit price for these items. We may list the unit price for the item, and the supplier may charge us based on the used item only. So the answer here is also B. Now, also a question about pricing arrangement. In a request for quotation, a buyer requests that responses to RQ include a pricing schedule on a cost plus basis for a research project. Is this a good approach for buyer to take? Okay, so this is a yes no question. There are 4 options. The first option argues that yes, and it means that the buyer does not have to review the supplier cost. Second, no, there may be more of an incentive. C, no, because you have a strict budget and we may need to use fixed price. And D, yes, the buyer will know the cost. So I think that let you decide. Okay, so for this question, what option do you choose? Please type down your answer in the chat. Okay, so we have duet, Molimo, answer with D. Okay, so I see that the option so far, the answer so far selecting D, right? But I have a different opinion here. You know that this is a cost plus basis, and for a research project with D, it means that the buyer will know what cost will be at the beginning of the project and allow for this in their project budget. With cost plus, this is not how cost plus work. Actually, this only works with fixed price or lump sum contract. We already know the whole price for the contract in advance, and we prepare the budget for that. But this is not how cost plus work. Cost plus means you pay the supplier the actual cost plus a markup for them. So the total cost here is not known yet, actually. Here, I think that the better way is to select the incentive system. This is a research project. It is pretty unknown. For a research project, it is quite risky, and we don't know yet what kind of outcome could be. It could be a success or it could be a failure. And budget for this one could be quite, it should be flexible. But since we want to control to a certain level, we may create a pain share, gain share agreement. Under this, again, under this arrangement, then we set up a target cost, and then the supplier, if they perform under that and provide a successful project, then we can share the gain. Otherwise, they must pay for the pain. Okay, so I think that this works better for research project where we have a lot of uncertainty. Okay, so for a research project, I believe that an incentive is better rather than we use cost plus or fixed price contract. Now, the time for my presentation is over, and I hope that you learned something helpful from this event. If you have further inquiry, please contact us on WhatsApp or to our email. And currently, we are putting our practice question on Udemy on sale. You may apply the code in the chat. That is exam vibe 25. Okay, exam vibe 25 is the applicable code here. So thank you very much for your participation today. I hope that this provides you with very helpful information on L4M3, and see you again in other events. Goodbye.